Good morning. Today is Thursday, January 27th. It's 10:55 a.m. And this is the second half of the morning session of Senate Natural Resources and Energy. We've been taking testimony on S-148, an act relating to environmental justice. Just did a walkthrough with our counsel, Ms. Chakowski. And now we're going to turn to our colleagues at ANR get an initial response and help us get the dialogue started. We've had to date some very sort of high level discussions, but finally now we're starting to see words in black and white between the four corners of a page, and it's going to help us start to dig in and get specific and get working on the bill. So welcome to the ANR staff. Maybe before we get going, you could introduce your team.
That sounds great. Thank you, Chairman Bray. Appreciate the time here today. For the record, my name is Maggie Gendron, and I'm the Deputy Secretary at the Agency of Natural Resources. And I will let the team who's here with us today, which includes the Commissioner and some of our legal support, just provide some context. All of these folks have played an instrumental role at the agency in progressing our work on environmental justice and civil rights compliance. So without further ado, I'll pass it over to Commissioner Walk to introduce himself, and then I'll let you pass the stick from there, Commissioner Walk.
Thank you.
Thank you, Secretary Gendron. For the record, my name is Peter Walk. I'm the Commissioner of the Department of Environmental Conservation. It's nice to be with you all again today to talk about this very important topic, and I will hand it off to Caitlin.
Thank you. Good morning, senators and witnesses. Caitlin Ellerman. I am an attorney with the Agency of Natural Resources. For the last 3 years, I've been on the Department of Environmental Conservation's Environmental Justice team. For the last 2 years, I've been on the Agency of Natural Resources Diversity and Equity Committee. And as Deputy Secretary alluded to, supporting efforts generally on environmental justice, as well as our civil rights compliance. And I am honored to be here today to talk about the pending environmental justice bill.
Great. Thank you, Ms. Ellerman. I don't know if you've spent much time with us before in the committee, so welcome to Senate Natural Resources and Energy.
And I'm Rachel Stevens. I'm an Associate General Counsel at the Agency of Natural Resources, relatively new to the agency, but have a background in environmental justice legal work.
Okay.
Glad to be here. Thank you.
And welcome to you, Ms. Stevens. So thanks so much for joining us. Turn
Great.
it back over to you.
Thank you so much.
Senator McDonald.
Jude, I perhaps inadvertently off video, and it says by the host. So if that could be corrected, thank you.
You just request video.
Apologize for the interruption.
Okay, so we'll
It's
sort out.
not working, but go ahead. I'm here.
Okay, so we'll sort out.
I, for the record, don't believe that he's here. I just want to be.
No,
I was gonna say how much better you look.
Busted.
All right. Well, eventually we might get this technical hiccup unhiccuped. So with that,
I'm hoping we get it fixed by May.
Wish come true.
Be investigating any kind of special transactions between Senator Campbell and
there we go.
the IT department. All right. Okay. So now we're more or less all here. Back to you, Madam Secretary.
Thank you. I appreciated that. I needed to laugh today. So that was a nice way to start this morning. So as you noted, by just the introduction of our team, we have quite a few folks who are have expertise in this space who are helping us progress what is work that is important, and it's resource intensive, and it takes time. And while we have the Department of Environmental Conservation, who has EPA oversight, Environmental Protection Agency oversight, this work impacts all of the departments at the Agency of Natural Resources, not just one. this work impacts many different agencies, as this bill alludes to. So I think it's important to keep that context in mind as you're moving forward. This particular subject matter doesn't belong to any one agency. It is a collective effort to support communities that are looking for some just procedure, policy, decision-making in the work that we do on behalf of our communities. So with that said, before I turn this over to Commissioner Walk and also to Caitlin and Rachel to also provide some more context and answer any questions, I wanted to just put a spotlight again. I was able last week to do a high-level conversation with other stakeholders at the table who I think very highly of. So I just wanted to again highlight 4 particular pieces of this particular legislation and possibilities for recommendations moving forward. One is the section that focuses on spending 55% of funds identified in areas in designated environmental justice populations. 2, there's a couple of pieces on the rulemaking section that I wanted to provide some recommendations on. 3, I continue to think that we should have focused discussion on the advisory council and interagency council structure. And then 4, just a comment on funding and the need for this work. As I said, it's resource intensive. So I'm working with one computer today, so I'd normally be able to cite a page number and then move to the comment. And I can't do that right now. So I'm going to just go to the dedicated fund section, which states it's in the chapter 726002 part D that talks about the 55% of environmental, renewable energy, climate mitigation, transportation, and climate resilience funds designated to environmental justice populations overburdened or underserved. I'm going to step back for a second before I talk about a recommendation there, which is I had mentioned last week talking about the President Biden's Justice 40 initiative. And so I wanted to clarify what that is for anybody who is also listening to your committee testimony today, and also just provide some insight for the senators here today. So the Justice 40 initiative, the Environmental Protection Agency is charged to track investments, benefits, and outcomes in environmental justice. And there has been a National Environmental Justice Advisory Committee that was established. And so the administrator of the EPA is charged to track state investments through that advisory council. The Justice 40 is an executive order by the president that requires the EPA to track the benefits of those investments. And finally, the EPA is also charged through their long-term strategic plan to commit to tracking the reduction of disparities in communities with EJ concerns. So again, there's really 3 focuses of the EPA in investments, benefits, and outcomes. And so this bill talks really about the funding percentage. And I had talked to Justice 40 last week, and I wanted to make sure it was clear that focuses on benefits.
May I ask a beginner question here?
Please.
So it seems natural when we're talking about environmental justice that we have the Agency of Natural Resources in here, but as you were saying, the law under Title VI, et cetera, applies to all federal funds in all operating areas. How is it just that EPA has been more active in terms of its work with the state of Vermont that has you in basically as kind of a leadership role relative to other agencies? I mean, it seems like you're sort of going first, and I'm just wondering if that's because EPA is more active in this regard than some of the other operating areas.
I'm going to let Commissioner Walk help me with this question, but in terms of any agency receiving federal funds, that deals with the Civil Rights Act of 1964, which is Title VI compliance that we reference in this bill and when we talk about it. So that's the That's the requirement and mandate by receiving federal funds, that you have to be compliant with that. In terms of environmental justice, the EPA has oversight of that particular body of work. And so there are different ways in which you can apply an environmental justice lens, and it can be in health, it can be in transportation, it can be within natural resources. And so in particular, the EPA is our federal regulatory body over our agency. And so we spend a lot of time speaking to that. So I'm hoping I'm answering your question, but I don't know if Commissioner Walk, you feel like you want to add some more context to that.
Thank you, Deputy Secretary Jedrin. I think Maggie did a good job of laying out the sort of distinctions here. I think I wouldn't necessarily say that we're alone. I would say that, you know, one of our key partners in this work has been the Department of Health, that has been looking at social determinants of health and other things that are really, you know, measuring environmental burdens for some time. And has been a great partner in this, and one in which I think you should definitely hear from through this process. And I think is sort of been maybe absent to this point, but I would welcome you to invite them in. They're obviously very busy with lots of things at the moment, but this is critically important work, and work that they take a lot of pride in the work that they've done so far, and there's lots of work for you to build from.
Okay.
And so I do think it's important to make sure that we, as Maggie mentioned, sort of separate that. It's easy because they're overlapping in nature, the civil rights compliance and the environmental justice work. It's easy to sort of think about them as one and the same. And for the purposes of law, I think we need to make sure that we hold them separately so that we can think about them differently. But I do think they are related, and so, you know, everybody has a civil rights compliance component. The Environmental Protection Agency has been focused on environmental justice for some time. The Justice 40 initiative is really the federal government's effort to expand that beyond the EPA, and that applies to not just EPA. But it's not, to my knowledge, it's not every program in the federal government. And so there's a lot of detail to it to make sure that we're doing it well. And that's some of the conversation we've been having already about funding, about what do you count and how do you make sure that we're getting the environmental benefits or reduced burdens that we're trying to achieve.
Well, thank you for that. And, you know, part of the reason I ask is because the bill was referred to this committee and just this committee, but I want to make sure that we have our eyes wide open enough to be looping in our colleagues in other committees, like Health and Welfare, for instance, to have them part of the conversation as we move forward. So thanks for that.
Yeah, I think that is a thoughtful consideration. So just to close out this conversation around this, what I had highlighted as the 55% of, it says the state shall spend at least 55% of environmental renewable energy, climate mitigation, transportation, and climate resilience funds in designated environmental justice populations and overburdened or underserved communities, provided that those funds are not already reserved for certain populations. And so, again, I had mentioned earlier, there's the National Environmental Justice Advisory Council, which many of the states that we have been talking to and looking to that are going through either similar legislation or have already passed legislation have looked to that council as a body to resemble some of the work after. And so I would recommend that we establish that 55% as a goal, which is similar to what that advisory council has done with the funding component of what they're tasked with, is establishing a goal and then having the advisory council charged to evaluate an incremental amount of a percentage, whether it be 20, 45, or 55, and advising agencies in the state on the methods for reaching that goal. So I think that this body of work is really important. And I think that if we can build in ways to take steps to get to where we want to be, as opposed to pass legislation that tries to make us be where we want to be immediately, might be helpful.
Thank you.
I really am trying to go fast. So if I hit a point where everybody hits a wall and we need to move on, I am happy to submit this in writing too. So I have 3 more points and I'll try to be quick. The second one is on rulemaking. Within the rulemaking section, I think it's a subsection D, under chapter 72, it's section 6003, and I think it's D. It says if more than 25% of the members of the Advisory Council on Environmental Justice are opposed to any proposed rule as determined by a vote, the agency must reconsider the proposed rule and prepare a revision. That I am flagging because that would be the first time in my understanding of moving authority away from a rulemaking process into a body like this one. And so would recommend that we encourage an expression of consultation or engagement with the council in the actual drafting process and also through the formal rulemaking process, so that the council's feedback to that rule would be taken into consideration before there's any substantial adoption. The third part I wanted to talk to is, and I'm happy to pause if there are any questions, but the third part I wanted to talk to was the Advisory Council and the Interagency Council. I think this is an incredibly important part of this legislation, and I believe could even warrant a separate discussion based just on what both you and Commissioner Walk highlighted, which there's other stakeholders that should probably be brought into the fold, including agencies and folks who would be a part of the Advisory Council, and what those expectations are for authority, because it's trying to respect that the Advisory Council would have some tangible feedback loop into the process, while also trying to understand what that would mean for the implementation of procedures and policies for agencies and how does it impact those agencies. So 1, I would suggest that you have that discussion. 2, I would suggest if we have a review if the right agencies are at the table or if we're missing anybody. For example, it was highlighted the other day that the Natural Resources Board is not indicated in this legislation, and should they be? I don't know the answer to that question. And then a couple of components of the council where there's in section 6004B, where it talks about the development of community engagement plans and this advisory council approving each agency plan by a vote. I would recommend a different approach than the word approving. I would probably recommend that the agencies be informed of those engagement plans by the council work, and that perhaps that the council establishes guidance or expectations on what needs to be incorporated into each agency plan, as opposed to approving each agency plan. And then there is another piece in the Advisory Council, I believe it was E, where it talks about receiving and reviewing the state agency summaries of complaints alleging environmental justice issues, including Title VI complaints. And this is the part that I highlighted, and recommend options to state agencies for the resolution of those complaints. I do not think it's practical to have this body recommend options for resolution of complaints like that. We have a procedure and process that needs to take place to resolve those, and believe that ANR could definitely provide annual summaries on the complaints that we have received and how they were resolved, and have the council provide recommendations on how to improve those operations moving forward. And then I'm going to wrap up this with talking about funding. I understand that funding is such a difficult conversation for every space that you want to make a difference. And I understand that resources are instrumental to moving things forward and making progress in a timely way. But I don't want funding to be the reason why we don't do something. So in lieu of the possibility for funding in order to provide resources, I would ask that we at least then acknowledge that there needs to be time allocated to do the work. I would argue that the Agency of Natural Resources, our departments and our staff who are incredibly committed, are at a bandwidth of their workload. And so this is and also this is a subject matter that I know that a lot of our, my agency colleagues care passionately about this, and everybody wants to do this well and don't want to feel like they are underserving the communities that we're trying to create some justice in. So I will stop there because I know that there's more expertise at the table here than me. And thank you very much.
Well, you're welcome. This is, it's an inadequate amount of time for us to, we're really in the getting started phase. So I appreciate everyone moving themselves along, but I also don't want anyone feeling like it's a speak now or forever hold your peace moment. We're peeling away layers on the onion. And so we're still on layer 1 or 2 here, and we will allocate more time. We'll be back on this bill next week. And so thank you for that. And I just want to reassure people, or if someone's listening and they go, wow, they're moving awfully fast. Well, it's because we're doing a pass now, but we're going to keep on bearing down and getting into more details as we work. So with that, I don't know who you want to go to next.
I would like to go to Commissioner Walk next.
Thank you, Maggie. Thank you, committee. I have my first printed out bill in 2 years. It's very exciting. It feels nice to have some paper in front of me. This is an important one, and it's nice to have gone through it. So appreciate this being in legislative bill form. It's familiar, comfortable for going through for that sake. So I'd like to skip over the findings for now. I think your discussion about findings is an interesting one, and one that you should continue on with. I think that's it has all sorts of pieces to it, but I'm not going to enter into that for the moment. I think I'd like to focus from the definitions on. And what I'll plan to do is kind of walk through what I think are high level considerations for you to think about, and invite colleagues in to help and flag things and answer questions as you have them. I would say interrupt us as we go. I think it's important that we think through these topics. So please feel free to interrupt me. The first definition is the first definition that I want to flag for you, and that's the cumulative environmental burdens. Ultimately, I think that is one of the more consequential definitions, and the application of that, which is referred to, or the implementation of it later on in the bill, is really the area of huge impact. If we're thinking about how that would apply, I'll give you a hypothetical. And this is something that the New Jersey statute, which is one of the gold standards of environmental justice law around the country, really focused on this cumulative environmental burden, that looked at whether or not a additional facility or additional industrial activity or additional permit would essentially tip the scales in a community from it being some level of not being overburdened to being overburdened. And that is something that is easy for you and I to speak about in conceptual terms, as New Jersey has gotten into how do you apply that from a regulatory standard perspective, and how do you do that work to understand how do you evaluate, because ultimately it's a question of whether or not a permit can be issued for a new facility. And so you have to have defensible standards in order to be able to withstand those challenges. And so one of the things I'd like to highlight for you is the immensity of that work, and partly because the science around how do you evaluate cumulative environmental burden is not where we would like it to be nationally. And the application of that is important, and it really should involve a consultative process for folks to understand what that would actually mean. And so right now you have a definition that we are, mostly to refine through rules and to figure out how to apply it within a year's time. And I think that is a real challenge to be able to get that right. And I would like us to think a little bit more about that as we move forward.
So thank you. Just so I understand that in sort of whatever concrete terms, might this involve something like a proposal to build a factory or a new highway through an area, and now you need to assess air quality and decide whether or not this would push air quality to a lower level, and now, although the amount of emissions associated with that plant or that highway in and of itself wouldn't necessarily be burdensome, taken into account with the pre-existing conditions on the ground, you've now sort of crossed a threshold, and that's, so you might deny such a permit. I mean, is that the kind of analysis you'd be going through?
Yes, that's precisely it. And so where is that line? That has been the concern that has driven many environmental justice actions across the country, is the idea that our permitting thresholds allow for some level of impact. And we can talk a little bit about the not insignificant piece that Ellen flagged before, but at what level do those individually permitted entities collectively create an undue burden on a community? And that's not an easy calculation to do, and it's an important one for us to think through, an important one for Vermonters to engage in on that discussion. So just flagging that as a really important piece, and it's really in that work that many of the other states have focused in actually defining sort of what constitutes an overburdened community, or what constitutes the analysis that would go into a cumulative impact analysis, that sort of thing, that where most have focused. And this bill is somewhat silent on that analysis and that process. And I think it's really important that we don't miss that here. So I'll move on.
Well, just one other comment, on rulemaking, if we don't set out clear and transparent guidelines at the outset of the rulemaking, no matter how well intentioned or executed, can deliver results that parties might not be satisfied with. So time up front is usually a great investment in terms of trying to get better outcomes in the end, is my experience.
I would agree with you, and certainly as a regulatory agency, we appreciate that, because it is difficult for us to interpret things that where there are, it's subject to interpretation. So moving on to the second definition of environmental benefits, I appreciate all of the components thereof. I do think as we think about definitions in statute, it's important to think about how the law gets applied, and how we would incorporate some of the balancing of those environmental benefits, or the equitability of the access to those environmental benefits across the board. I think, we've done a good job sort of over time societally identifying things like food deserts, and where there's equitable access to healthy food, trying to figure out how to do that with the access to green jobs, I think, as an example, might be more challenging. So I just, trying to think about making sure our definitions are doing what we intend them to do and have that effect, and are able to be applied in a manner that's consistent across the board. Moving on to definition number 3, the environmental burdens on page 9. I do think what Ellen flagged about the not insignificant impacts, as well as the resulting from intentional or reasonably foreseeable causes, phrase should be thought about in great depth, and we should do some analysis as to whether or not what that means to the previously authorized regulatory programs at the Agency of Natural Resources and in other places where you have essentially set up permitting structures that allow for some some level of environmental harm, that is sort of the nature of a permitting process, to recognize that we want to do better in some activity that's been occurring and put standards around those things. And so those are, reasonably foreseeable environmental harms that we as a state have chosen to authorize. And so I think thinking about how those two things interact will be an important part of this conversation. I do think there might be some analysis, and I'll grateful to Caitlin for pointing this out, that the Washington environmental justice law, known as the HEAL, I believe that's an acronym, Act, has some good definitions of environmental burden that might be useful in this context, and something that we can draw on what is, another one of those sort of gold standards in environmental justice legislation.
Commissioner Walk, I didn't catch what you just said in terms of what you referenced. I couldn't hear it.
Their definition of environmental burden, I think, is a little more specific and might be, easier to implement over time. It's something that we should look at the words on their page and see if how we think they compare.
And what I missed was what you were citing, like the document.
Washington HEAL Act, HEAL.
Thank you.
I'll jump in, Commissioner and Senator Bray. It's the Healthy Environment for All Act. And I actually would say it's not these definitions, they don't look dramatically different than those definitions, but that definitely worth referencing in terms of perhaps fine tuning what you see here.
Okay, thank you.
Yeah. And then, small flag that our colleagues at the Environmental Protection Agency offered on the definition of environmental justice. There seems to be a sort of moving back and forth between equitable distribution and proportionate distribution, and their feeling was that those should remain consistent if they're being used interchangeably. I just wanted to flag that for you as a normal thing. Also, I think where Ellen highlighted at the bottom of the environmental justice definition that environmental injustices hasn't been defined might be useful as well, to think about what that definition means. So moving on to definition 5, which is environmental justice population. In their comments to us, the EPA flagged that the definition, the thresholds that are identified here within census block groups are novel to their mind, but they again aren't living in the Vermont demographic context, and so can't speak to that necessarily how it would be applied in Vermont, but it's not a definition that they've seen before. I did want to, as a geographer by training, I did want to help you all with the definition of a census block group. Well, a census block is usually something that has a sort of tighter geographic boundary and doesn't necessarily relate to a sort of full population size. A block group is a combination of blocks that is usually in the 600 to 3,000 person range, and gives you a sort of slightly larger group of people beyond what would normally be considered sort of a neighborhood block. So hopefully that's helpful.
Thank you.
I am also interested in the discussion that you had. So this is thinking about the environmental justice population definition. You brought up with Ellen the notion of the petition process and the sort of threshold for 10 residents to petition the Secretary of A&R. We have different petition processes within the agency. This one is definitely novel to my reading, but I could be wrong, and we're happy to dig into it a little bit more if that would be helpful.
Sure. You know, I think that I think I understand the thrust of it. It's to create a mechanism for accessibility to bringing forward a complaint or concern. But then I wonder, once it's like, okay, if we open the door into a process, then what happens inside the room? You know, like how do we, in an orderly way, consider it, resolve it, come to a conclusion? Can someone appeal the conclusion that has been drawn? You know, all that kind of stuff.
And then it's an interesting notion, because we're looking at that section of the definition. The sort of first hurdle that has to be hit is that a portion of the census block group meets one of the threshold definitions, and then the petition can occur. And I'm not sure, you know, that creates an interesting burden on the community to have to prove that. And I'm not sure how they would, if you know, maybe the census block data goes down to that low enough threshold that it helps us be able to identify that. But I just want to flag that may be a petition process that is burdensome on the part of those looking to be added as an environmental justice community.
Okay, thank you.
Definition 7, the meaningful participation, please. This is a sort of more of a question that I have, and I think it might be useful for if Ellen has a perspective, or the Attorney General's office might have a perspective on this. So that meaningful participation is defined as that all individuals have the right and opportunity to participate in all the things that follow. And I think trying to understand how a right in this context would be evaluated through legal proceedings would be really interesting. You know, if we, you know, I can think of examples where an individual chooses not to participate given the opportunity, but and then makes a challenge because they were denied the right. And I'm not sure how you balance those two factors and how the court would. So I think it's worth some discussion. I understand the intent here. I agree that the opportunity to participate should be available to everybody. I'm just not quite sure how, from a legal context, how that would work. And moving to the overburdened or underserved definition, but it certainly, as we work to define that definition and its relationship to environmental justice communities as they're defined, and the funding component, the 55% funding component, there's a lot of uncertainty in that space at that point. I think that depending on how broad that definition or narrowed that definition becomes, you may have ended up in a situation where, as Elena described last week, the mapping that they have done based on the definitions that are currently in there as an environmental justice community would cover 52% of Vermont's population. If we then add overburdened and underserved communities on top of that, and then apply the 55%, we may end up in a sort of strange situation where we are underfunding those areas in strange ways. And so I'm just trying to think through what those look like, and so that we can all go in with clear expectations. I think that's one of the things we've talked about a couple of times. And some of the nature of your questions with Ellen this morning is about, let's make sure that everybody goes in with clear expectations so we know what comes out of this process. And again, for moving on to the environmental justice state policy, section 6002, on line 13 where it says consider cumulative environmental burdens as defined by rule, how that consideration works and what it means for individuals who apply, for individual businesses, whomever apply for permits, and how we apply those criteria and how we use that consideration is really one of the key points of where the environmental justice, the process, the work that we're doing to advance environmental justice really meets the traditional environmental permitting world. And I think that's really significant that we do that well. Moving on to 6002B, I think it's one of the things that we have learned through the work that the department has done and the agency as a whole has done on environmental justice is really being well schooled on the nature of how we developed community engagement plans and how that works, and the fact that it shouldn't be a top-down developed plan. We shouldn't write a plan that doesn't speak to the needs of the communities that we're trying to communicate with. And so we've done that. We've slowed down. We have a contract in place to help us engage with different communities around Vermont to understand what works well, what doesn't work well, what are some of the things that we should incorporate into our work as we go forward. We're not due to get that report back until the end of this year, into next year, and then we'll be working on the plan itself. And that's us being ahead of other state agencies as they think that through. So meaningful engagement in developing that, moving at that speed of trust is really important. So I think we need to be really careful with the timelines associated with the development of those plans so that we can have the time to do those things thoughtfully. I also want to, one other note on the funding piece, and this specifically relates to the reporting back that you're asking for of several agencies and departments, is that there's this expectation that we have a sort of a dot on a map that shows lat long and address location of all of the state spending. That isn't necessarily the case. And so tracking that information is probably going to be not as clear as some might like. I'd like to use the example of the money that you've supported in terms of funding towns and cities doing stormwater work along roadways. That stretches out over a long period of space time where it could be divided up amongst different census block groups and tracts in a way that would be difficult for us to count where precisely that was. And so there was then some language at different points considered about sort of to the extent practicable. And I think that might be something that you consider in that reporting, just so that we create clear expectations around what's possible.
Yeah, I think that weren't we mapping roads in 10th mile increments? And I think that went on for, I don't know if it's even entirely complete yet. So we obviously, there's, the different ways in which we spend different funding is tracked in different ways. And we, it may be that most of the project is in one specific location and that cost could be spread across the sort of the linear nature of that project. And I'm not sure that's appropriate either. And so I just try to think through and not set false expectations for you all and for the public on terms of what state agencies are going to be able to provide. So I'd like to move on to the rulemaking component in 6003, if I can.
again, I'll keep coming back to the cumulative environmental burdens because I do think that's really important. So that timeline of doing that within 1 year, I think is just impractical and not something that will be to the benefit of the overall effort if we don't have the time to engage with the council, with the public through this process. So I just want to keep reiterating that. And one of the key points of that is you have both define and implement, which I flagged early on. The New Jersey law, for example, sort of defined how that would be implemented and left the definition up to rules, but the implementation was that cumulative environmental impacts would be evaluated for the siting of a facility of above a certain size. And so in this instance, you haven't either defined or developed the implementation as it stands now in the bill, and it leaves significant work left to be done that can be done via rulemaking, but that should be done with the appropriate amount of time and care. Again, in the rulemaking section, so paragraph C, you have there is a process for the Agency of Natural Resources in consultation with the Advisory Council and the Interagency Council to review the definition of environmental justice population. That's not a rulemaking, just substantively, that's not a rulemaking process, and I would encourage you to move that to a different section of the law. It might be more appropriate down in the reporting component or some reporting component that would be in session law at the end of the bill, but it isn't rulemaking per se because we would be making recommendations to you. One of the things that in subparagraph D of that section that is something that we've been thinking a lot about and hearing what you've heard from other stakeholders in this process about the desire for the Advisory Council to do substantive work in support of the state's efforts and to ensure that that work is included in that effort. We have for some time been doing sort of informal stakeholder work prior to the issuance of rules, right? We engage with interested parties to talk through what the key features of rule updates might be important from various perspectives. And we work through some of those big picture things before we get to a formal public process. It helps with education, it helps with discussion, helps us work through things that were in our blind spots that we didn't see. I think there's an opportunity here to build that into the Advisory Council process so that, I would think of it as a sort of the first step is to work with for state agencies to work with the council to sort of scope what a rulemaking might entail. There would be some sort of interim check-in point where we say, here are some ideas that we've thought of. What do you think? And then a review of a draft set of rules before they would go to ICAR. That's how, if I'm in charge of managing the process, we would do it anyways. And I think it might be worthwhile to think about that as a process for the Advisory Council to put their expertise and experience into the rules as opposed to what is laid out here. I think that it's important for the substance and for that expertise to be integrated from the beginning and have that co-creation process. I don't think that that's effective at the end of a rulemaking process. One of the things that, and this is sort of a late breaking process in the development of this draft, and I'll, sort of moving on to 6004 and thinking about the nature of the interaction between sort of, I would say, three parties, right? You have state agencies that are referred to. You have the interagency body, which is, you know, most of the sort of key state agencies, and then you have the advisory council. And how those three entities interact, I think, will be really important to conclude. So we make sure that that work is done in a you know, coherent and as unified fashion as possible, so that as where it says that the advisory committee will, or advisory council will advise state agencies, should that be advise the interagency committee, so that there's a more coherent sort of flow of information. That is just something for you to consider. It feels like we need to spend a little more time thinking about how this might work. And I, you know, speak to that, thinking about it from the context of the Interagency Committee on Chemical Management and the Citizens Advisory Panel that we have as part of that work, and the way in which that flows. There's sort of a clearer process, and something that we should think about as we work through these things.
Yeah, for instance, along those lines, there's only 4 required meetings, and so that leaves a lot of time as individuals and individual groups to be working in order to come back together again and make progress between meetings. Not that there couldn't be more, but there's a lot that's undetermined in order to make it a productive thing. And probably everyone's been on a group that meets so infrequently that it's hard to get kind of a critical mass of work going because meetings are so far apart. So.
And I'd like to come back to that point when we talk a little bit about per diem in the end, and the discussion that Kaya and others brought up the last time we were here about the extractive nature of some of these processes for unpaid volunteers, and the fact that the per diems are inadequate to account for the work that needs to go into that. We need to be very careful about that process and the expectations that we're setting. But I'll come back to that in the end. I also want to flag on page 17, I'm kind of, so in 6004 sub C in the duties, in C1A, thinking about reporting back to you on the definitions of an environmental justice population. I think that what is laid out here in terms of ways to make that definition more inclusive presupposes the expertise and the experience of the advisory council that may want to put forward an entirely different definition of, or an additive component thereof that isn't related to the things mentioned. And I think we should allow for that advisory council process to speak to its own set of definitional changes and make that recommendations without your input on what should be included, right? To make that a true advisory body would allow them to think through their own set of recommendations, and then in conjunction with the interagency group to put forward those recommendations. That feels cleaner to me. Just trying to think. I've hit on some of these and don't want to take up all of the time.
Well, you know, just so I'm looking at the clock, and obviously we're not going to have time to provide enough time to all our witnesses. So I apologize. As the time manager, I could see we're running long, but I didn't really see an intermediate speed for us to go at, unless we just wanted to go around the track. So I think we're going at the right speed for now, and we'll reschedule. My apologies to Ms. Mahali that we're not, you know, but also everyone should rest assured that we'll be back on this topic soon, and everyone will have ample time to work.
Thank you, and my apologies to the other witnesses as well. But I think some of these things are important for us to consider, And
Sure.
I appreciate the time to go through it. I did also want to note that thinking about the advisory council and the membership, there's the definitional piece that Ellen highlighted about the sort of creation of an environmental justice population definition and a overburdened and underserved definition is that sort of the distinction between the environmental justice populations based on demographic thresholds that have been proven in data analysis to be predictive of the likelihood of being overburdened or underserved traditionally, whereas an overburdened or underserved has specific data that community has sort of met that threshold. And so I think we speak to membership being with a significant number residing in environmental justice populations. I wouldn't want to exclude overburdened or underserved populations at that point either. And it just highlights the sort of that balancing point between those predictive versus responsive definitions. So that comes up both in the sort of overarching guidance about a significant number residing in environmental justice populations, and specifically in the note where it's on page 20, sub C, where 2 representatives of the community affected by environmental justice concerns. Affected by environmental justice concerns, again, is not something that's defined, and I think could be construed as either an environmental justice population or an overburdened or underserved population, but it's a little unclear to me, and I would want the Committee on Committees and Speaker of the House to understand how they were supposed to appoint in that context. And then I'm going to skip ahead because we've spoken to a bunch of this stuff in various contexts already, but thinking on the second to last page on some of the pieces associated with the council, I wanted to flag 3 things for you in 6, 7, and 8 at the end of 6004. First, the 6 provides that the advisory council shall have the administrative, technical, and legal assistance of the Agency of Natural Resources. That is the same language that exists in the Global Warming Solutions Act. We have, as the agency, have endeavored to provide that support as much as possible. But I will note that as of right now, there aren't the resources to be able to do that work. And it was a struggle to be able to do that, and even with the resources provided on the timelines that were provided for the Climate Council. And I just want to flag that we are not able to provide that level of support without additional resources. It's simply we do not have the resources to be able to do that.
Now you just know how popular you are. Everyone wants to loop you into the program.
And that is not for a lack of desire. We have a huge group of folks who are picking up this with a small percentage of their time because that's what they can squeeze out of from other duties to be able to make progress, and that's important. And we've brought Carla Raimondi on at the agency level to help with a bunch of this work and to make progress, but it's insufficient to do the level of work necessary that's envisioned in this bill. And so we should think through that carefully.
Well, and sorry to interrupt, but thanks for bringing that up, because I always feel like you're doing exactly what our committee often does, which is to say, if we're ever talking about legislation that adds work and it's not within your current capacity, to please flag that for us, because if we're going to ask for the work, then we need to pay for the work. And because we want people to succeed, we don't want to overburden people. It's not a good work environment to just simply heaping more tasks on the same team. So
it also relates to what we are asking of a volunteer council as well. And I've heard this multiple times from members of the Vermont Climate Council and the various subcommittees that have supported that work, that they wish there was additional staff capacity to be able to assist with some of the basic work. And that went well beyond that desire, and that the ability to support went well beyond the resources that were provided for the Climate Council. And so it was inadequate even with the additional resources that were provided to meet everybody's expectations and to make participation more equitable for those who are not doing it as part of their paid employment. Sub 7, the Secretary of Agency of Natural Resources shall implement recommendations of the Advisory Council to the extent that they are consistent with that chapter. I think I understand the intent. Again, it goes back to what you just said, actually, Senator Bray, where you said, what are we asking you to do? And do you have the resources to be able to do them? There are going to be things that the Advisory Council wishes us to do and that we would support doing, provided the resources to be able to do them. And I think that that's an important thing that we need. It's about expectation settings just as much as anything else. And then finally, I'll anchor again on the per diem component of this, both in conversations with the stakeholder group that put together this language and our team. We wanted to make note that as we've gone out to do work to engage communities, we've made sure that compensation for people's expertise and time is a clear component of that work, because we are asking of people to share their expertise and their experience and what we can learn from it. And the $50 a day, $50 a meeting in per diem is insufficient to enable somebody to put the amount of work necessary to do this effectively in the Advisory Council. And so as you're thinking about the balance between what the tasks that you're asking of the Advisory Council and the importance of that work, bear in mind what somebody who would have to take time off of paid work to do this effectively would have to give up in order to do that and make sure that they're compensated accordingly. I can't say that strongly enough. And I think that's sufficient for now. There's so much to this. There's so many opportunities for us to make meaningful progress in the state of Vermont with regards to environmental justice. And I agree with your statement earlier, Senator Bray, that as we look through this and we really get into the words, it is about making it better and making it implementable and making it meaningful for the people of Vermont. And I appreciate the opportunity to be with you here today to work on that.
Okay. Well, thank you. I don't know if Ms. Ellerman or Ms. Stevens, if you were here for sort of technical expertise on the fly, or I'm just wondering if we should be scheduling you to be back as well, because there are things that you are going to be adding to today's conversation that you haven't had a chance to get to, and we're 1 minute shy of adjournment for the morning. Well, I'll leave that to Madam Secretary to assemble the team that you want whenever. That's a standing invitation.
Yeah, I think you're looking at a key part of the team. It's not all of our group. We'll try to be here together as much as possible so that we can all bring our expertise and answer questions as you need them answered. And
again, apologies.
We travel as a pack.
Okay, safety in numbers. And to Ms. Mahaly and Ms. Byrne, thank you for coming. I'm sorry that we didn't want to sort of push ourselves along so fast that we couldn't have the kind of meaningful conversation that we all do want to
Understood, Senator. No problem.
Right. So we will be scheduling this again next week. So watch for an invitation. There you were wondering, what are you going to do next week? And now we're going to take some of that anxiety away. That we'll be back at work on this 148. Okay, so thank you, everyone. It's been really helpful discussion, and I look forward to continuing it with all of you. And with that, committee, it's noon and we are adjourned for the day. Thank you.
Bye. Thank you.